Good evening, everyone. I welcome each one of you to our Advocate on Record Aspirants Academy. This is our 40th lecture. Before we go to the topic, it is our regular practice that we recite preamble of the Constitution of India, because the soul of the Constitution is embedded in the preamble. So it is our bounden duty to remember our founding fathers, what was their goal, and their goal must be our mission. So I request each one of you to recite preamble along with me. We the people of India, having solemnly resolved to constitute India into sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Dear friends, this is our lecture number 40. The topic is continuation of the procedure governing special leave petition in criminal matters. Most frequently asked questions. Either you are given an option to draft special leave petition in civil matter or a criminal matter. Day in and day out, we also draft, as a practitioner in the Honorable Supreme Court of India, special leave petitions, civil as well as criminal matters. So our bounden duty is how to draft. Before drafting any petition, you should know its origin, the origin of the power, where it has originated, which rules governs special leave petition, and what is the procedure prescribed by the Supreme Court rules. Only thereafter you can start drafting a petition. So in precise, we can say that you must know the facts and the law, then everything is taken care of. So therefore, dear friends, my approach to the topic is, I will take you to Article 136 of the Constitution of India. And what does it say? Thereafter, the Supreme Court rules 2013, and then which particular order and the rule which deals with SLP criminal matters. So this is our approach towards the topic. Now let me take you to Article 136 of the Constitution of India. Article 136 of the Constitution of India is an extraordinary appellate jurisdiction of the Supreme Court. Why it is extraordinary? Yes, it differs from the other appellate jurisdictions like civil appellate jurisdiction, criminal appellate jurisdiction. Unlike those jurisdictions, this is extraordinary appellate jurisdiction. Reason is, other appellate jurisdiction is generally arises out of the final order or the judgment or the degree passed by the High Court. It goes to the Supreme Court by virtue of Article 134 capital A, where the certificate is provided by the concerned High Court. Therefore, it becomes a civil appeal or a criminal appeal with respect to the cases are concerned. But as far as the extraordinary appellate jurisdiction is concerned, what is extraordinary in this? Reason is, SLP can be filed against any order, number one. Any order means it can be a final order. It can also be an interim order passed by any court or tribunal. It doesn't say it arises out of the High Court. It says passed by any court or tribunal. So therefore, meaning thereby, any order, even an interim order passed by the trial court or by any court or tribunal, the SLP can be filed. So therefore, this is how it is distinguished from the other appellate jurisdictions. Powers are very wide and it is entrusted with the Supreme Court. When the powers are wide, when the powers are unlimited, it is sparingly exercised, cautiously exercised, not in general that the Honorable Supreme Court will invoke its discretionary power. Dear friends, I said it is extraordinary appellate jurisdiction, meaning thereby it is not our right to file under Article 136. On the contrary, it is a discretionary power vested with the Honorable Supreme Court to see whether it is a fit case to admit or to issue notice to interfere with the order passed by any court. So Article 136, let me repeat, the Supreme Court, notwithstanding anything contained in this chapter, chapter 4, the Supreme Court may in its discretion grant leave to appeal against any judgment, against any degree, determination, sentence or order. So how do you remember it? JDDSO. If you put it in abbreviation, JDDSO, judgment, degree, determination, sentence or order, passed in any matter by any court or tribunal in the territory of India. So that is Article 136 Clause 1. Then Article 136 Clause 2 is an exception to Clause 1. So Clause 2 says, Article 136 Clause 2 says that the order or the judgment or the sentence passed by any court or tribunal constituted under the armed forces, the SLP will not lie. So Clause 2 is an exception to Clause 1. So this is what the structure, essence of Article 136. Now, how to deal with procedure governing SLP criminal matters, for which we need to peruse, study, investigate the Supreme Court Rules 2013 by virtue of Article 145 Clause 1, which empowers the Honorable Supreme Court to frame its own rules. So therefore, by virtue of Article 145 Clause 1, the Supreme Court rules has been framed. So which provision is relevant for SLP in criminal matters? Order 22. Order 22 of Supreme Court rules deals with SLP in criminal matters, dear friends. So now let me take you to the concerned provision. Order 22, dear friends. On the last occasion, we have seen from rule number 1, order 22, rule number 1 to rule number 5. In essence, I can tell you that what is the format of SLP criminal matter. The format is prescribed under form number 28 appended to Supreme Court rules with certain modifications. Because if you look at form number 28, it says civil appellate jurisdiction. So therefore, here the order 22 says with certain modifications with certain cosmetic changes with respect to the rules are concerned. Otherwise, the format remains same like form number 28. Fine. Thereafter, the annexures, whatever the annexures you file, it has to be filed separately. It cannot be filed collectively. Then affidavit. Affidavit has to be deposed by the deponent by saying that whatever the facts that are stated in the special leave petition are true to his knowledge. Affidavit is considered to be an evidence. You are deposing, you are giving an evidence. Therefore, if there is a false statement either in your petition, that means you may be punished for giving false evidence before the court of law, or you may be punished for the contempt of court also. On the last occasion, I have narrated what I have witnessed before the court of law. By mistake of an affidavit, how an illiterate woman has lost her entire property. So affidavit is the soul to the entire petition. Then we have discussed about how SLP criminal matters are filed. It is through two ways. Either you approach the concerned High Court to issue a certificate. When that certificate is not granted, then after the rejection of your certificate, you've come to Supreme Court by way of filing special leave petition. Limitation is 60 days. Otherwise, it is 90 days. Exception is only if it is involving death sentence. So this is how broadly we have discussed, dear friends. If you wanted to have a elaborate or discussion on this, you can watch our YouTube video lecture number 39. Now it is only the continuation from where we have left. Now let me take you to rule 6 or rule 4 of order 22. Now the question is, before reading it, let me ask myself this question. Because when you are drafting a special leave petition, SLP supported by an affidavit, and in the list of dates and events, you will give the dates and the material events, and you will keep or you will annex a true copy of FIR. A translated copy of FIR is annexed as annexure P1, annexure P2. So when you keep those annexures, when you annex those documents as a part of your SLP, what sort of annexures you can find? The general rule is you have to get the certified copy from the court. A certified copy from the court, that alone is acceptable. What is an exception? If you are unable to get the certified copy, then in the affidavit you can say whatever because some documents are available with the advocate, then it has to be certified that it is a true copy. You have to certify there it is a true copy of the original. So this is an exception, but in general practice we file the true copies only. So let me read that rule, dear friends. Order 22, rule 4. No annexures to the petition shall be accepted unless such annexures are certified copies of documents which have formed part of the record in the court or tribunal sought to be appealed from. So it should be a certified copy, that is the rule. Provided that uncertified copies of documents may be accepted as annexures if such copies are affirmed to be true copies upon affidavit. Hope this is clear. Now let me move on to rule 5 of order 22. Now we are dealing with SLP criminal matter. So when our client is in jail because the High Court convicted him for imprisonment, now he is in jail, he wants to prefer special leave petition against challenging the High Court order. So how will you prove before the Honorable Supreme Court that your person is in jail? Therefore, he requires bail. How will you prove it? When a sentence is passed and he is undergoing imprisonment, how will you prove it? That is the question. The answer is, after the verdict of the High Court judgment, whether has he surrendered before the concerned court. If he has surrendered, there will be a order passed by the trial court saying that he has surrendered on such and such date. Therefore, produce the certified copy of the order of surrender. This is one way of proving that you have surrendered. Or alternative, you can file a certificate, maybe it is called as custody certificate, issued by jail authorities, superintendent of prison, jail authorities will issue a certificate that he is the convict so and so, the remaining sentence of conviction, then what is the sentence that he has undergone, everything will be given. So this is yet another way of proving that he is in custody. Is it clear, dear friends? Either by way of order, certified copy of the order stating that he has surrendered before the court, or a certificate issued by the jail authorities that he is in jail. Now my question is, on wakalatnama, if there is attestation by the jail authorities, because wakalatnama is executed by the client, he will sign at the place of the petitioner, and if it is attested by the superintendent of prison with his signature, is it a sufficient ground to prove that he is in custody? The answer is no. Mere attestation of the jail authorities on wakalatnama is not sufficient to prove that he is undergoing imprisonment, that he is in custody. Is it clear, dear friends? Otherwise, if you do not file a custody certificate, the registry, Supreme Court registry will not accept your special leave petition. It will remain in defects. But there is only one exception is there. What is the exception? An application seeking exemption from surrender. An application seeking exemption from surrender, if it is filed, assuming that the sentence is for 1 year, and he had already undergone during investigation already 3 months. So remaining period is very, very less. So once he files it, he needs an exemption from surrendering. Otherwise, once the matter comes up, he must have exhausted, he must have undergone already the imprisonment. Therefore, SLP will become infructuous. So therefore, in such a scenario, he can file an application seeking exemption from surrender, that imprisonment is itself for 1 year. Therefore, your lordships may, until you decide the SLP, grant me exemption from surrendering. This is one way. Yet another way is he is terminally ill. He is in coma stage, or he is not in conscious state. How he can be taken to the jail? So therefore, when he is terminally ill, when he requires 24/7 monitoring by the doctors, so in such a scenario, medical conditions, he can move an exemption from surrender with supporting documents. So these are all the scenarios, situations where he can move an application for exemption from surrender. So once SLP is filed with an application for exemption from surrender, what is the next stage? The next stage is only application will be listed, not the entire SLP, dear friends. Only application for exemption from surrender will be listed before a single judge. Now, there are two possibilities. One, They can allow the application for exemption from surrender by satisfying that honorable court is satisfied that this is a fit case to exempt surrender, therefore allowed. This is one possibility. Another possibility is rejected. Application is rejected. You should surrender. Therefore, once it is application is dismissed, application for exemption from surrender is dismissed, means the honorable court will record surrender within 2 weeks, surrender within 4 weeks, time will be given. So once he has surrendered, then proof of surrender has to be filed. Only then matter will be listed before the court for considering a special leave petition. Otherwise, the matter will not be listed. And even the Honorable Supreme Court has power to pass such an order if it does not surrender within 8 weeks or 4 weeks, and he does not provide the custody certificate, the matter, the SLP may be dismissed without even reference to the court. Therefore, you are tying his hands and legs to come and surrender, then only we will hear you. So therefore, this is the situation, dear friends, with respect to the proving of your surrender. Now, let me read it for you what the rule says. Exactly what I have stated. Rule 5 of Order 22, where the petitioner has been sentenced to a term of imprisonment, the petition of appeal shall state whether the petitioner has surrendered, and if has surrendered, then the petitioner shall, by way of proof, what sort of proof that he has to give? File the certified copy of the order of the court in which he has surrendered. So he will prove the certified copy, or otherwise a certificate of the competent officer of the jail in which he is undergoing the sentence. These are the two options by which he can prove the surrender. Now, a mere attestation of the signatures on wakalatnama from the jail authorities shall not be considered as sufficient proof of surrender. So, mere attestation on wakalat shall not be sufficient. So, when the petitioner has not surrendered to the sentence, the petition of appeal shall not be accepted by the registry unless you file the surrender certificate. It will not be listed, except unless it is accompanied by an application for seeking exemption from surrendering. Where the petition of appeal is accompanied by an application for exemption from surrendering, that application alone shall be listed for hearing. It is not SLP will be listed, only application shall be listed for hearing orders before the court in the first instance. Now, SLP is filed. Assuming that he has surrendered, SLP gets listed before the court. Then what is the next stage? After curing the defects, matter is listed before the court. Court hears a petitioner, advocate on record on behalf of the petitioner. There are two possibilities. Firstly, matter is dismissed. There is no merits in the case, matter is dismissed. If the notice is issued, notice will be issued to the respondents. Respondents may be the state. Offences against the offences is considered to be offences against the state. So maybe this any state, notice will be issued to the state. If the de facto complainant is there, maybe the respondent number 2. Once the notice is served on them, what is the time limit for them to file objections? That is affidavit in reply to the special leave petition or counter affidavit. What is the time limitation? It says so, dear friends, the respondent shall be at liberty to file his objections within 30 days from the date of receipt of notice, not from the date of notice, not from the date of order, but from the date of receipt of notice, or not later than 2 weeks before the date appointed for hearing, whichever be earlier. If a matter is listed before that 2 weeks, it has to be filed, or 30 days, whichever is earlier, he has to file it. This is complaints of natural justice, audi alteram partem. Here the other side. You heard petitioner, the Honorable Supreme Court is convinced prima facie, therefore notice has been issued to the other side, the state. Now the state is supposed to file its reply within 30 days or 2 weeks, whichever is earlier. Now, Rule 7 of Order 22. Now, what happens here, dear friends? Our client is in jail because he is agreed out of the High Court order. High Court order has sentenced him to imprisonment. He has surrendered. He is in jail. He engages an advocate on record by paying fees, and then we file his case. That is one possibility. But he is of no means. He is very poor. Client is very poor. So how will he approach the Honorable Supreme Court? So a prisoner, after conviction by the High Court, is undergoing a sentence in jail. He will explain his grievance to the jail authorities because he can have access only to the jail authorities. He will request to file SLP on his behalf. So the jail authorities, whatever the materials available, maybe the court records or the High Court order, whatever the possibility is, jail authority will write a letter. To whom? To the registrar of the Honorable Supreme Court. That here is the prisoner who wants to prefer SLP and he is not in a position to engage an advocate on record. Therefore, he requires a free legal aid. Please provide. So once the jail authorities receive from the prisoner, they write a letter to the registrar of this court. The registrar of the court peruse the materials, peruse the documents. It may be sufficient or it may not be sufficient also. If it is not sufficient, the registrar may call the papers, documents, relevant material, documents from the court, maybe from the High Court or from the trial court to provide necessary papers. So once all the necessary papers has reached the registrar of the Honorable Supreme Court, the matter will be referred to the Supreme Court Legal Services Committee. So Supreme Court Legal Services Committee has a list of panel of lawyers. I proudly and humbly say that I am also a part of the Supreme Court Legal Services Committee. So we provide free services, but we are paid also by the Supreme Court Legal Services Committee. So we provide free services to the litigants, or even the panel lawyers from the state can also be provided. So lawyers from the Supreme Court Legal Services Committee can be provided to the litigant, or from the panel of lawyers maintained by the state can also be provided, and fees will be paid accordingly, dear friends. So this is how a free legal aid is given to the poor, is provided to the poor. Here what is being reflected? Access to justice. Access to justice, Article 21. That is a fundamental right. He may be a poor. He may not be in a position to reach the highest court of the land, but still he cannot be denied the access to justice. So therefore it is provided through Supreme Court Legal Services Committee or through the state panel lawyers. So I am not reading that Rule 7, dear friends. I am moving on to the next rule. Now, Rule 8. On the granting of the special leave, the petition for special leave shall be treated as a petition of appeal and shall be registered and numbered as such. So when we file special leave petition, notice is issued. Other side has filed objections within 30 days. Now the pleadings are complete. Now the matter is before the Honorable Supreme Court. The Honorable Supreme Court, on hearing the both sides, state on the one side and the petitioner accused on the other side. After hearing both the sides, the Honorable Supreme Court may dismiss the specially petition also even after issuance of notice. That is one possibility. Next possibility is they can grant leave. What is our prayer in the specially petition? The Honorable Supreme Court may grant leave against the impugned order passed by the High Court in criminal number so and so. So the Honorable Supreme Court may grant leave. Leave granted. So prayer granted. So SLP criminal takes the avatar of criminal appeal. See how? From diary number to SLP criminal number, from SLP criminal number to criminal appeal after granting of leave. So now leave is granted, dear friends. At the time of granting leave granted only based on the arguments. So when a bench is granting leave, they will know what is the facts involved. They know what is the issue involved. They know how much time it will take. So therefore, if the Honorable Supreme Court is of the opinion, the consent bench is of the opinion that this matter may take only 2 hours or 3 hours. So that can be intimated, recorded in the order, and then the registrar should maintain a separate list where short matters, where the matters which will consume very limited time. So that can be maintained in the separate register. Therefore, the Honorable Chief Justice of India can constitute a bench and hear these short matters. I read that Rule 9 of Order 22, dear friends. While granting special leave in all matters in which the bench granting special leave is of the opinion that the matter is capable of being disposed of within a short time, say within an hour or two, it will indicate accordingly the office shall maintain a separate register of such matters to enable the Chief Justice to constitute a bench for the disposal of such matters. So now rule number 10. So once leave is granted, then the Honorable Supreme Court Registry may call for the records of the courts below, because it becomes a criminal appeal. So it goes to the root of the matter. Appreciation of evidence is permissible, may not be under 136, but under criminal appeal. Once leave is granted, it becomes a criminal appeal. Therefore, everything can be adjudicated, appreciation of the evidence, and all the documents, material documents can be perused. Therefore, call for the records from the courts below, from the High Court. So the registrar will send a notice that leave granted matters, send all the relevant documents. Sometimes the Honorable Supreme Court may adjourn the matter that the entire record has not been received. Therefore, we are adjourning the matter. So entire records, once it comes to the Supreme Court, why entire record is required? Because as a petitioner, one who files a special leave petition may not file the entire deposition. He might file only few deposition which goes in his favor. So therefore, but in order to provide justice, they need to see everything. The Honorable Supreme Court has to apply its wisdom by considering all the material documents. So therefore, they will call for the records. Let me read 10 and 11, dear friends. Rule number 10 of Order 22. Upon an order being made granting special leave to appeal, the registrar shall transmit to the court appeal from a certified copy of the order together with the certified copy of the petition for special leave and the affidavit, if any, filed in support thereof. Rule 11. On receipt of the said order, the court appeal from shall give notice of the order to the respondent and require the parties to take all necessary steps to have the record of the case transmitted to the court in accordance with the directions contained in the order granting special leave. The registrar of the court appeal from shall certify to the registrar of the court that the respondent has received notice of the order of the court granting special leave to appeal. Now rule number 12, dear friends. What does it say? Because under article 136 clause 2, we have studied now that any order, any sentence, any judgment, any determination passed by any court or tribunal constituted under the armed forces SLP will not lie, right? Then in such scenario, when an order passed by the arms tribunal, then where the appeal will lie? The answer lies in rule 12 of order 22. The provisions contained in this order shall apply to an application for leave to appeal to the Supreme Court under section 31 subsection 2 second part of the Armed Forces Tribunal Act 2007. So there is a statutory appeal provided under Armed Forces Tribunal Act itself to approach the Honorable Supreme Court. So when there is a statutory appeal, therefore there is no requirement of article 136 need not be invoked. So therefore, dear friends, once it is a statutory appeal filed under section 31 subsection 2 of the Armed Forces Tribunal Act, what is the format? What format that you will file that statutory appeal? The same format as provided under order 22. With such modifications and adaptations as may be necessary. So the provisions contained in this order, that is order 22, shall apply to an application for leave to appeal to the Supreme Court under section 31 subsection 2 second part of the Armed Forces Tribunal Act 2007 with such modifications. Because here you will not say article 136, you will say 31 subsection 2 of the Armed Forces Tribunal Act. So with such modifications and adaptations as may be necessary. So therefore, dear friends, we have seen the order 22, the procedure of the Supreme Court rules governing SLP in criminal matters. So in essence, we have seen article 136 of the Constitution of India. Article 145 clause 1 empowers the Supreme Court to frame rules. Based on that constitutional provisions, article 145, Supreme Court rules 2013 has been framed. In this, more particularly important provision is order 22, which deals with criminal matters, and we have seen the entire from rule number 1 to rule number 12 of order 22. Now in the next session, we will come out by drafting special leave petition in criminal matters itself. We will take out the previous question papers from this book, because we have already have the questions, previous question papers have already been provided in this. We will take out some important question based on which we will draft special leave petition in criminal matters, dear friends. So with this, I am really honored to deliver a lecture on this particular and important topic. Thank you so much, dear friends. Thank you.